All right, it is now 5:40. Today is February 12th, 2014. Call this meeting of the Urbana Human Relations Commission to order. Can I have a roll call, please?
Francis Rigberg Baker,
Here.
Daniel Larson, Lisa Mosley,
Here.
Tyler Morrison, Peter Resnick,
Here.
Aisha Lam Sobe, and Rizwan Udin.
All right, well, we do not have a quorum at the moment. Hopefully, one of our other members will arrive. We're just one short, but we will go through other items which are mostly for review and comment. I don't believe any particular vote is coming up. So we will have to skip approval of the agenda, although are there other items that we want to add to the agenda? All right, and we'll obviously have to skip approval of the minutes. Our next item of business is public participation. I see a couple of folks in the audience. Does anybody wish to address the commission?
I kind of wanted to wait till y'all talk a little bit and then.
All right, so did you all want to talk to a particular agenda item?
Yeah,
The prior conviction enforcement
Adjournment.
guideline? Yeah. Right. Okay. So, well, and actually, it is our next item of business. So, if you want to talk to that now, or did you want to wait for the introduction from Todd, and then we'll that'd be fine. So, Todd, why don't you introduce this item, which is under item 6, under item 5, old business, A, review and comment prior conviction enforcement guidance.
So, very late this afternoon, or late today, I released another draft, and we forwarded it to everyone, of the rewritten rule. It is just the rule itself. I've not attached the comments, and I haven't completed the comments. But this is what I have so far. Last month, I discussed basically making it into a piece of guidance. When I went through and tried to sort of retrofit the rule to that type of orientation, it became clear that certain aspects of the document are proscriptive, and there's no way to get around that. There's no way to make it advisory without seriously compromising sort of the underlying logic and integrity of the document itself. And so upon reflection, I determined that probably the best thing to do was to keep it as a rule, to emphasize to everyone who's interested that this is a rule that articulates the Human Relations Office's the way that the Human Relations Office will view and enforce this particular protected class status. And so in terms of substantively, other than that change, really the only real change, and this was actually evident in the draft that was presented in December, is the identification. Well, first of all, it is the inclusion of specific language from the ordinance under the section that explains when employers may actually deny employment to individuals with prior conviction. So it basically pulls the language straight from the Human Relations or Human Rights Ordinance for that section. And then the second major change is the inclusion of the factors that are identified by the EEOC as factors that should be used in order to do an individualized assessment once you have determined, or once an employer wants to assess whether or not a particular conviction and the particular circumstances of that conviction, whether or not they would fit under the exception. They should go through this multi-factor analysis to determine whether or not, under the circumstances of the individual conviction and the position that's applied for, whether or not it actually would fit into the exception. So those are the major changes that were made. And I'm happy to take any questions that you may have. The rest of the changes were cleanups and a couple of linguistic additions basically to make it clear that this rule is articulating and really putting everyone on notice exactly how we will evaluate in my office, how we will evaluate whether or not a violation may or may not have occurred in terms of making the initial determination, which is mandated in the ordinance itself. So that's all I have.
All right. Did folks from the audience want to comment on, and by the way, were you intending on a vote for final approval?
No,
anyway,
not today, because I just got you the draft, so it'll
Okay.
have to occur. But one of the things that I'd like to stress is, we've been talking about this for a while in the community, and I see no reason. Typically, when you put in a notice requirement of a year, it's not actually a notice requirement, but a year effective date for the following year or a year following the passage of a particular rule, you're doing that just to put everyone on notice. We've been discussing this in the community for quite a while, and so you'll also notice in the draft that I put that whether or not it's passed on next month or whenever, it's going to be effective January 1st, 2015.
Yep.
There's no reason for it not to be.
Right. And it will, in effect, I think, be a resolution from us endorsing this as your enforcement rule.
And that, I believe, would be the most appropriate action.
All right. So, comments from the public on this topic?
Should I go here? Or
Yeah, please. And go ahead and introduce yourself. And
The whole official business. Okay.
yeah,
James Kilgore, 511 South Draper Avenue, Champaign. Let's see, a couple of questions and then a comment. Okay, so what you're saying is that if it's now our rule, the process for approval, a change of rule, what the process for approval is?
well, so I think I understand the question you're asking. So this is proposed as the way that the HROs start enforcing complaints. That is, if a complaint is brought and the facts, the requirements set out here are not in place, that will be an indication that the person has violated the ordinance and might get likely to get a probable cause finding. If they followed all of these guidelines, they will be presumed to. But that will, as of January 1st, 2015, be the way that the HRO will be enforced.
And the only thing that needs to be done for that to happen is for the Human Relations Commission to approve that change.
Well, I believe the mayor has to at least be okay with this. But, well, Todd, why don't you speak to this a bit?
So, yeah, and I've had several conversations with the mayor about it, and I believe that she is supportive of the change. And you may want to think of this as just a notice of, at some point, if you change the way that you're enforcing a particular rule, no matter what system you're in, whether or not you're an employer or a branch of government, you have to tell everyone, hey, this is the law that we're enforcing. Up until now, we've enforced it this way. Now we're enforcing it that way. And that's really what this constitutes. It's just fair notice to everyone that when we evaluate these, and particularly when it comes to the inquiries that occur, inquiries into someone's prior conviction that occur prior to the making of a contingent offer, that's what I'm really concerned about. This basically just puts everyone on notice of exactly how they can do, how they can make, when is the most appropriate time under the ordinance to make those inquiries. And so that's really what we're trying to do. And I don't want to unfairly surprise anyone, any employer. I want every employer to be able to comply. We want to make it as easy as possible to comply, and part of that is issuing a notice. So yes, my office would like a resolution from the Human Relations Commission when we have a quorum and when they've had a sufficient opportunity to review the final draft. But beyond that, it takes effect on January 15th. Now, and I should stress also that this doesn't mean that we're not enforcing this as a protected class now. We are. And in fact, this is one of the most effective areas of enforcement that we have. in terms of being able to get settlements and being able to get real results for people. This is just sort of saying we're even going to expand the way we're doing this to bring it more in alignment with the other protected classes.
And
well-
do keep in mind that the current ordinance, which is what started this whole ball rolling, the current ordinance effectively bans the box. It just wasn't being enforced in any particular way. And
No,
so
okay.
the enforcement rule going into effect means that we're going to take notice of people who have continued to ask the question.
Well, I mean, I think I think we're fairly aware of the process and the content. So that, I mean, I would just say that the concern that we would have is just that we get this done. We've been at this for over a year, and it still hasn't gotten to the mayor. In the intervening time, we've seen the state of Illinois pass a ban the box resolution. We've seen other states and cities pass ban the box resolutions. And I think, I mean, we've worked. I think we worked very well together on this with the Human Relations Commission. But it seems that we've kind of hit a little bit of a lull in the action. And so I'm just hoping that we're going to actually push ahead with this with all deliberate speed. I mean, even the Attorney General is now talking about felony disenfranchisement and so forth. This is becoming an important issue, and I think it would do well for Urbana to actually finalize this and be able to join the ranks of cities and counties and states that have taken action on this as soon as possible. So, I mean, I hope that we'll have, you know, some urgency as we move ahead with this to get it resolved. It doesn't seem like there's a lot left to be done. That would be correct, I think.
My feeling is that you will see the resolution to put this into effect on next month's HRC agenda, on the commission agenda, to just go ahead and approve the resolution to go ahead and do this. Given that the human rights officer has been talking to the mayor, I don't see any impediment to this being implemented immediately January 1st.
Okay.
I think it's a done deal.
Okay.
My opinion.
Okay, well, my interpretation of a done deal is when it's actually
Done.
So I appreciate that, and I'm hoping that that's correct. But let's apply everybody's definition.
I share your enthusiasm.
Okay, thank you very much.
Any other comments? Yeah, so commission members, please.
So this does not involve the city council.
Not at all. There's no change to the ordinance.
Sometimes it gets confused in my mind with the taxi thing.
Right.
Sorry.
Right.
Okay.
No, there is no change to the human rights ordinance in order to make this go. So, all right. So we will review for. I'm sorry. Please.
Aaron Ammons, 1108 North Busey. So the enforcement that takes place now, because Todd, you did speak to, I had wrote that question down. I think there must be some spy cameras in here or something. So the enforcement right now, is there going to be a difference in the penalty, so to speak, for anyone? So right now, even if someone came up and had adequate proof that they were discriminated against based upon a felony background, there's a certain process that would take place, and that same process is what would take place as of January 1st, 2015.
Yes.
Okay. That's it.
Thank you.
Yeah, if you just want me to ask any kind of question.
No,
okay,
you
all right.
can. No, I think we're good. All right. So, any other comments or questions from the commission? Then we'll go over this for typos. I found one, but I'm quite pleased with the final result. I think it says exactly what we've been talking about. So we'll go over it to make sure. But for next month's agenda, we'll have a resolution to approve or to endorse it on the agenda. All right. I've got to learn to turn off my little screensaver. So going on to item 6, new business, if my screen will come up. Do you have a copy of the agenda? agenda?
I do.
It's the unconscious bias.
Ah, the unconscious bias, yes. So Todd, go ahead and give
So-
an introduction to this topic.
Yeah, I'm just going to request that we put this on next month's agenda. I'm still looking for reading materials that would be suitable to submit to the Human Relations Commission right now. The best article I have is 70 pages, and I wanted to save you that. But basically, this is just to begin a conversation about the standards under which employment discrimination can be found, and taking a look at the current legal standards and asking whether or not under the Urbana Human Rights Ordinance, whether or not there may need to be some expansion based upon recent socials, or recent as in 2002, 2003. So I'm using that term loosely, but recent social science research on implicit bias and how that may be affecting groups that are considered to be the other. So, but I'd like to actually have a serious conversation about that next week, if that's possible, or next month, if that's possible.
I think this is a great topic. For those of you who have never done it, at the Harvard website, the implicit association test is just a lovely little reminder. And you will find some of the results saddening to know that you have these things, and sometimes the results you will find are very funny. I have interesting associations on certain of the topics that they present. So, in any event, yes, that's a great topic, and I'm glad that you've pushed this along. All right. Now, let me just look at the agenda if there's anything else that we can handle. Well, we can at least take the staff report. With regard to the EEO workforce statistics, is there anything that is going to be of urgent need that you want to get our input on, that you might need to administratively approve before next month's meeting?
You know, I'm not sure. So what I can do is if we have to do that, we can handle it administratively this month and then bring it back to the commission for final approval. If that's okay with everyone.
Both of them are one-year approvals, which
Right.
means that you're still in contact with them, but not knocking at their door next week.
Right.
Um,
In terms of the HRO activity report, you can see here that we've had a couple of inquiries since last month. Now, again, I was out for 3 weeks, so that may have reduced the number. In terms of the complaint activity report, I'll just note that currently we have a mediation scheduled to deal with UC 110603 and UC 130303. That's the same case. We have a mediator coming in from Iowa to hopefully try and get that resolved. And the other ones are all basically in some stage of the process.
May I ask?
Sure.
May I ask where mediation is being
Oh, sure.
required?
It has a lot of the case has a lot of moving parts, or the complaint has a lot of moving parts, and both of the parties have attempted to do some settlement over time, and both agreed that at some point getting everyone into the same room with someone who is trained in sort of striking agreements would be the best thing at this point, rather than going forward, or at least, trying to do that in order to avoid the public hearing, both sides. And so at this point, we've got it scheduled. If it doesn't work, then we'll get the public hearing back on the books. Any questions on these? All right, that's all I have.
All right. And the budget report, I take it nothing has moved.
No.
Excuse me. All right. Any further announcements? Yes.
I just wanted to share and thank all the MLK organizers and participants. It was awesome. I really enjoyed it. It was very interesting. And I was just watching it again last night. Our speaker was very interesting, and also just the whole thing on education and how that came to be. I appreciated her time.
I'm sorry I wasn't able to be there in person.
I represented.
All right, seeing no further announcements, so anything by way of approvals will just bump until next meeting, and this meeting is adjourned. Thank you all.